July 2018. She told her supervisor, Nomfundo Luana, as well as Mr. Jonathan Kumalo, an assistant manager with the disaster measure, which she did. Captain Swart visited the stadium on the 1st of August. She informed him that she gave the cartridge case to Luana. Sergeant Tuze took photos. Or how she handled this, that he was informed by the witness by 2018 when the incident occurred. He was unable to say whether it was gunshot, Pomo, and Ms. Luana, and they confirmed the discovery of the spent cartridge case. He and placed it in the SAP-13 register with SAP-13. The firearm and liquor section of SAPS is a manager. Mr. Ndluli, where all the firearms of the business were recorded. On the same day, 2 firearms, a .223 Norinco SPA-2 Funtla and a 9mm P Glock handgun were presented for inspection. This witness did, however, no conversation between him and accused number 2. Testified that he is a regional manager with a private. It's alleged that accused number 2 is a manager, and confirmed that accused number 2 was at some point at that stage also co-owned by Mr. Licenses to handle shotguns, handguns, and rifles. Testified. Unit of the SAPS in Kaveh, which was found at the Cesar Cae Stadium after the incident. They collected from the Mdansane SAPS, both accused fingerprints were expanded in for further tests to be were then tested by Lieutenant Colonel in Kabeja for comparison, and found 3. So received several firearms which were sealed in evidence bags. 49-14 rifle. Compared this rifle with the spent cartridge case that was case. He concluded that the spent cartridge case was fired from the. He also noticed that the serial breech block consisting of the firing pin, and that this did not correspond with the outcome of the ballistic test. But despite these changes to the breech, it was indeed fired from the said firearm. An opportunity to examine the exhibit under the supervision of Colonel Ndlwa made on the cartridge case form part of the breech block that were removed after. The evidence of Mr. Taken, and it remained consistent. We Singh, Samuel Kwata, and Sizibu Singh. It was hired. So basically what they did, 204 subpoena had to be issued when the police visited, as they were not willing at that. Mr. Ashley Singh is the manager. He also possesses a license to have a firearm. He testified these video footages. Several shots with 2 different caliber firearms. During operated this particular video equipment, they confirm what they've seen on the video. Number 1, firing any shots because they did leave the video footage. Was also employed as a media liaison. Accused number 1 firing shots at the EFF. The video footage that accused number 1 forwarded the viral video footage to a particular incident which he did. Muzzle flash emanating from the firearm, and in his experience that real. On the 2nd of August, the viral footage from Colonel Swartboy was requested to compare the images firing shots with a rifle, and thereafter handing the rifle to accused number 2. She was able to identify the muzzle flash but confirmed that she was unable to confirm whether the firearms were indeed real or not. Accused number 1 and accused number 2. At the digital forensics section of the SAPS, and was requested to download the 2 viral videos from the handset. He thereafter downloaded it on a CD which is sealed. A copy. He did not tamper with the video. Also confirmed is attached to the digital forensic section of the SAPS, testified that the following day, the 2nd of August, requested by Colonel Swartboy to make still photos, which our accused number 1 fired several shots, were able to confirm the firearm, whether it was Captain Governor Muan Sandari, who was employed at the SAPS as accused number 1, firing shots. Observed accused number 1 firing several shots with a rifle and handing the firearm to accused number 2. The matter further. She also identified the muzzle flash of the firearm, toy or blank, a movie firearm. Firearms have muzzle flash when being fired. It was basically just to complete the chain tree. The only aspect about his evidence, how it, and that all these firearms were sealed when he received it at the Brighton Beach Police Station, ballistic section of the photo, with any of the exhibits that included the video footages, must make about the fact that Colonel Swartboy did not testify regarding the fact that the members of the SAPS that was employed as close Worship submitted that all these witnesses that testified were good accused before court. The evidence were objective, evidence in the manner in which it was led in court, starting with the evidence of accused number 2. Utilized his right to remain silent. With the accused number 2, transfer or the handing over of the fight. A conviction at all costs. My job is to assist a closer look again at the viral video reveals our accused number 2 was just at these shots. Number 1. Relating to that particular aspect beyond reasonable doubt. To the third video, which is referred to as the viral footage, particulars. Bishop, I submit I didn't drop the accused number 2, handed the rifle to accused number. Bishop, after making such a submission just for completeness, as the ballistic expert, sake of the completeness of the record, Martin Hood is a Bishop, in my view, this witness testified and interpreted the provisions of section 120, subsection 10, in brackets A, of the Firearms Control Act of 2000, which reads, "And give possession of a firearm or ammunition to a person who is not alive in terms of the act to possess such firearm or ammunition." Regulation 2021 and 2022 of the Firearms Control Act. A person working with a company firearm who possesses the qualifications to use any gun of the Firearm Control Act deal with a holder of a license may act, but subject to section 120, subsection 5, any person who is allow any other person to use that firearm while irrelevant and of no value. Bishop, I can refer the court to this particular matter of the Director of Public Prosecutions, KZN versus Matiani, where the professors of law to tell them what the law is called. It's still a mystery to me, which is expressed on an issue which is the court can decide without receiving such opinion. See State S versus Nell, the footing of a witness excluded not because of a need to preserve or protect the risk of confusion on the main. He testified, it's still a mistake. He didn't know what was going on. He testified to confirm that the accused is competent to basically possess a firearm. I've already read the evidence. Number 2, in his own evidence of this Mr. Wood, if he had insight into the facts and what had transpired from his own evidence, accused number 2, if you look, if the state had proved that he did indeed, if I didn't make that concession earlier, that there's accused number 2 would have been convicted of a particular offense if you look at section 120. And that the video relating to him handing the firearm over to accused number 1 or vice versa is obliged as an officer of this court to direct the court of the provisions of section 255 as accused number 2 is concerned. Otherwise, that you might not agree what I have just conceded relating to accused, to look at this provision of the offense charged but prove that the accused is guilty of any other offense of which he may be convicted. Myself will have a disagreement only on this particular part. That is, accused is guilty of an accessory after the fact charge. The accused may be found guilty and shall, in the absence of any other such punishment, shall not exceed the punishment which may be. Accused may even be charged for the offenses which was committed by accused number 1 if he is an accessory after the fact of that particular offense. In me and counsel for accused number 2, and that's a finding which the court will have to make relating to the interpretation of that particular section. The particular murder scene where a murder was committed, that is actually what this particular section is referring to. Particular section, Your Worship, that is for the court to interpret. Snyman's criminal law states as follows: a person is an accessory after the fact to the commission of the crime if after the completion of a crime he unlawfully intentionally engages in conduct, evade liability for his crime, or to facilitate such a person's evasion of life. In my view, my submission in this regard is that he's the only one that could have removed that bridge block and facilitated the removal of the bridge block of SPA 24940. The 2 ballistic experts state most of the evidence between us is commonly issue that was indeed a real firearm. 1 comes to this particular issue. Your Worship, I want to deal with the evidence insofar as accused number 2's witness, Ngwadleka, did not personally examine it's submitted that the evidence of the clerk cannot be taken seriously and should be disregarded and rejected. The clerk evidence is spent cartridge case. Explained and illustrated to court by Colonel Ngwadleka to show the court how he positively linked the spared cartridge. Ngwadleka testified, as I've already alluded to, that he received the batch of firearms, which included this particular firearm. He performed several tests on these firearms, numbers did not correspond with the rest of the serial numbers. So in other words, Your Worship, I stand to be correct. Firearms that he examined, and this from that 40 is the only right. Rest of the spent cartridge into how positive test. How do you make a mistake? This offense. Markings in the chamber or the barrel of, and it will be very area. It was conceded, it was indeed changed the bridge block. Rush through my things now. I will some portions of the record. This record was also forwarded to counsel for accused number. He did not perform any microscopic examination on either SPA. Examination was not an acceptable method. That Colonel Wadeka approach would be more accurate than his. The clerk further considered that he had last completed the comprehensive 9. He was employed since 1980, if my memory serves me correctly, until 1989, either 1982 until 19. Was last, which we know now, it's almost 30 years or more than up, which he observed on the spent cards, but conceded that the mere presence in that particular mark, according to Colonel Guadleca's relating to the firing pin